And when you have your initial meeting with the client, are you quite candid in terms of their chances and likely sentence?
Well, I think it's very important to be as direct and unmistakable in your advice as possible, because I'm afraid that a lot of people charged with criminal offences do like to, as it were, only hear what they want to hear. And by the time they get into a criminal trial, it's too late. So I like to give early and I hope realistic advice, both about the strengths and weaknesses of the prosecution case, but also what might happen if things go wrong.
And have you ever had to advise a client you can't represent them if they've come to you and said, oh, I've committed this offence, but I'm going to plead not guilty?
That has happened, actually, but it's pretty rare. In fact, it happened to me more as a solicitor than it has as a barrister, in particular in police stations where somebody might say, oh, well, this is what happened, but I'm going to tell the police this. At which point you have to say, well, no, either you tell the police nothing or you tell the police what happened, but I'm not here to help you lie. And if that is what you're going to do, then you'll have to get yourself another lawyer.
And it's right that if a client says to you, I've committed this offence, but I want to plead not guilty, they can still run the trial, but not put forward a positive defence. So it's letting the prosecution prove their case.
That's exactly right, yes.
And have you ever been in that situation in court?
Yes. In cases where the prosecution case simply wasn't, as it were, strong enough. So you can't call your client to give evidence. You don't advance a positive case, but you ask the jury or the magistrates whether they are sure that the prosecution has proved its case. And sometimes that means that someone who in fact is guilty, who hasn't given evidence, will be found not guilty because the prosecution haven't proved it. It's not the defendants got away with it, it's the prosecution who haven't proved the case.
And sorry to jump ahead, because I know we are going to come back and talk about your work as a prosecutor, but I'm just curious, have you ever been in a position where you have been prosecuting and felt the evidence is such a weakness that you found it almost quite challenging to put forward the case?
Well, in any case, you get papers and you read them and you think, oh, this witness has said A, B, and C. And then they go into the witness box and they say something completely different. And if you're defending, you think, well, this is wonderful. If you're prosecuting, you don't think this is wonderful. And you feel that your carefully crafted opening submissions to the court falling apart in your hands. It's part of the job. But also, yes, I'm asked to advise on cases quite frequently as to whether or not there's a reasonable prospect of conviction. You like to try and give realistic advice about that, looking at the evidence in the round.
And if you're sent a case by the prosecution, by the CPS, and asked to prosecute it, and you would get it on the morning of the trial, and you look through the papers, and you feel that it is a weak case, is it putting that to the prosecutor and asking them to review it, or do you ask them to discontinue it?
Well, you have a discussion with the reviewing lawyer, assuming you're able to get hold of them on the phone, and you'll say, look at this. Where is this piece of evidence? Where is that piece of evidence? Is this really an ABH or is it a common assault? Looking at the various different elements that you have to prove, and you then have a I hope, constructive conversation as to what the likely outcome is going to be. And sometimes that will be, we don't have a realistic prospect of conviction and therefore we're going to offer no evidence, or that we decide to prefer a lesser charge, or indeed on occasion, a more serious charge.
And if you are advised to run it, does it change how you approach the case as a prosecutor?
No, I think you still follow your instructions, but you have to be fair. that's the most important thing, it seems to me, if you're prosecuting, is that you should be unimpeachable in terms of your approach. And so you should not over-egg the omelette. You should not make unfair points or anything like that at all, because, well, I mean, it's obvious, it's very important, and you don't want somebody being convicted or on a false basis.
And I found over the last 10 years, prosecution cases, you find more and more pieces of evidence missing or things that haven't been investigated properly. Are you finding the same as a prosecutor or defending?
Well, it's the bread and butter of defence work, isn't it? Pulling apart prosecution cases and shoddy investigations and pointing out the whole, in any defence speech at the end of a trial, there's always a list of stuff that the prosecution should have done and haven't. And when you're prosecuting again, you're trying to spot the things that about which the defence will say that and say to the reviewing lawyer or the police officer, look, you need to go and get some evidence about this fact, because at the moment what we've got isn't really going to stand up, or you've only got hearsay evidence dealing with this point at the moment, and so on. Can we firm this up or not? Or just looking to see whether there are further inquiries that can be made that will either prove or disprove the allegation. And it's not a question of trying to make sure the indictment stays as it is. It's a question of investigating.
And can I ask, whether you're a prosecutor or defending, you mentioned sometimes you have a witness takes the stand and they aren't answering the way that you might expect them to. If that happens, what are your options?
Well, if you're prosecuting and your witness does that, then you are allowed to show them their previous statement that they will have made to the police, and politely remind them of what they said earlier. You can only do so, though, in chief, so not asking leading questions.
And do you feel your work as a prosecutor has helped your defence?
It has, because it allows you to see things from the other side and to know in more detail how the police procedures and CPS procedures work. And I think it therefore allows you, for example, to make more effective representations to the CPS.
Do you think it helped you having started doing police station work as well, seeing that side of the investigation?
Definitely, and it is. I feel that I'm in a not uniquely, but very privileged position now as a barrister, having spent a long time as a solicitor and having spent many hours of my life stuck in police stations advising suspects. A lot of members of the bar have never been in a police station custody area at all. I think it's quite helpful that I have been, and that also means in terms of empathizing with my client, that I've got a bit more insight into what things have been like for them.
And you mentioned earlier about funding and legal aid cuts, and how's that affected your practice?
Well, when I was a solicitor, it affected my practice hugely. The lack of increased levels of remuneration, coupled with procedural changes that meant that there was far less work being done in magistrates' courts, meant that it felt like it was death by 1,000 cuts. You had to constantly try to increase the volume of cases you were dealing with in order to maximize the amount of fee income. But the real fundamental problem was the fixed fee regime which was introduced, which, as the name of it indicates, it means you get paid exactly the same amount of money for doing a case, no matter how much work you do on it. And it really shouldn't take a genius to work out that rewards the indolent and lazy and punishes people who do a good job. In fact, that was one of the reasons that I chose to get out of being a solicitor.
What would happen to you if you were given a case and you prepared it for trial and you turned up to court the next day for it to be adjourned, and then the relisting date you weren't able to do and had to pass it on to a colleague?
I would be rather frustrated. And the reason I'd be rather frustrated is that I would be paid probably something like £150 for doing all the preparation. And I'm afraid that with the vast COVID backlog of cases, this sort of thing is happening more and more. Cases are being called on with no regard at all for whether the barristers who have prepared the case are available. And so it has two effects. First of all, the people who are doing all the preparation work aren't being paid to do it. And the people who are then presenting the case are getting the case the night before, which, as you can imagine, if you're about to do some public speaking involving life-changing issues for people, is very stressful.
Yes.
And it is, I'm afraid, a feature of life. It always has been a feature of life at the criminal bar, but I think it is now getting far worse as a consequence of everybody having to try and pull together to get through the vast backlog.
I know it's definitely stressful because I've been in a situation before where I've been given a case on the morning of a trial, told to drive to a court, never met the client before, haven't been able to read the papers before getting to court, and the magistrate expects you to get on with the case as soon as you get there. And it is incredibly stressful.
It is. And from the defendant's point of view, it doesn't have the feel of fairness. You can imagine if you've spent hours with your solicitor or barrister and then you're told, oh, in fact, your case has come in at short notice, nobody you've ever met before is going to be there. Of course, you're immediately going to have a crisis of confidence about those who are going to be representing you. It's absolutely natural to do so because you will think, but hold on, I spent hours with my solicitor. They know exactly what I'm saying. Why aren't they here? It does make it a stressful situation for everybody involved, but from the lawyer's point of view, it certainly makes for a stressful day at court, that's for sure.
And can I ask, because you mentioned a couple of times there in that response, this backlog that has also been in the press quite a lot recently, and it's quite often tethered to the notion of it being a consequence of COVID. What's your view on that?
Well, part of it is a consequence of COVID. However, part of it is not. The number of outstanding criminal cases at the beginning of COVID was about 30,000, I think, in the Crown Court. It's now double that. So the backlog was already in existence. And that was because the courts were not using the court estate effectively. The number of part-time judges that were being used had been slashed. And so it wasn't unusual even before the pandemic for people to wait 2 years, 3 years for allegations to be investigated and then tried before the Crown Court. Now, matters are unsurprisingly far, far worse. The Crown Court didn't sit at all for the best part of 8 to 10 weeks during COVID. But even now, many court centres are only able to do 2 trials instead of 5, or just 1 or 2 cases at a time. Thankfully, part-time judges are being used far more frequently in order to try and reduce the backlog. But it is a vast hill to climb. And of course, one of the problems is that part-time judges are experienced solicitors and barristers. And those experienced solicitors and barristers are then no longer able to do the cases they're meant to be doing if they're sitting as judges. So a huge investment has already been made by the government. And they've announced further money in the budget last week, but I'm afraid it's probably just a drop in the ocean, and it would not surprise me at all if we are still trying cases in a couple of years' time that relate to pre-pandemic events. I was prosecuting a case this morning, an allegation of burglary going back to 2019. So that's already 2 years old, and the trial won't happen for another 6 months. And that is absolutely not unusual at all.
Yeah. No, I've read instances of cases not being listed until 2024.
Yes, well, I haven't yet got anything in my diary for 2024, but I have, I think, got some things in my diary for 2023.
It's absolutely crazy. The fact that some defendants committed these offences, alleged to have committed these offences as a youth, and they go through 3-4 years later as an adult and get tried for the same offence.
Yes, exactly. And that is, it is unfairness that is currently endemic. It's unfair on anybody to wait 3 or 4 years with a serious allegation hanging over them.
Yeah.
It is particularly unfair if you are a youth and you're at a time of your life where you are still maturing, and you can't move on. You don't know whether or not to go to university. You don't know whether or not to finish the course you're on. But it's also unfair on victims or witnesses, people who want to be able to forget what happened to them and know that the person who did it has been found guilty and punished. They don't want to be constantly getting reminders from the witness service that they may have to go to court one day in June next year for something that happened back in 2019. But I'm afraid that is what is happening at the moment.